Well, I think a great starting place for us tonight would be to just understand where we're at currently with religious freedom. What basically does the law say we can and can't do? What are the limitations and restrictions on that as it stands at the moment?
Well, Mark's done a lot of work in this area, so I'm going to defer to him first, and hopefully I can fill in the gaps to the extent that there are any.
Okay, all right. Thanks, John. So, first of all, Australia has committed in its international treaty obligations to protect religious freedom and freedom of speech, freedom of association. Those three rights sort of go together. Freedom of speech is self-explanatory. Freedom of association is the freedom to associate with people that you want to associate with and not associate with people that you don't want to associate with. And you might think, how's that relevant to freedom of religion? And you think, well, the church. Right? Church is people of like mind and faith associating with each other, or a mosque or a synagogue, etc. So freedom of religion, freedom of speech, freedom of faith, protected in international law. But our international law obligations have no impact, almost no impact, on our domestic Australian law, the actual law of the land. So if you look at what the law is that protects us, that's either made by judges or it's made by one of our 9 parliaments around the country. And those laws do not positively protect freedom of religion anywhere, except for a provision in our federal constitution, section 116, which says that the Commonwealth Parliament, and only the Commonwealth, can't make a law for restricting the free exercise of religion. That sounds positive. Can't make a law for establishing a religion, and can't make a law which prescribes a religious test for public office. But the High Court, which interprets the Constitution, has read that guarantee of free exercise of religion very narrowly, and has basically said unless the law sets out to target a particular religion and a particular religious expression, it's not invalid. So, for example, a law against conscription, which landed very heavily on the Jehovah's Witnesses during the Second World War because JWs were pacifists, and was used to disband them, was held not to be an attack on their free exercise of religion because it didn't mention the JWs and it didn't talk about religion. So really, Section 116, in terms of free exercise, is, as currently interpreted by the court, is not at all helpful. And then the only other place, really, I'm going a little broad brush here, but the only other place really where freedom of religion is protected is in anti-discrimination acts around the country. So there are acts which say you can't discriminate against someone, you can't treat them less favourably on the grounds of race, gender, disability, age, pregnancy, breastfeeding, sexual orientation, gender identity, and so on, those sorts of things. And where religious freedom is protected there is that most of those acts, but not all of them, have an exception that says religious bodies and religious schools can, in some circumstances, treat people less favourably on the basis of those attributes. So it's an exception to the general rule that you can't discriminate if they are doing it in accordance with the doctrines, tenets and beliefs of the religion. So religious freedom in Australian law is protected really as an exception to other people's rights not to be discriminated against.
We also have some state charters which guarantee rights of religious freedom, and also discrimination acts in states which prohibit discrimination on religious grounds. I guess the takeaway is that there is a patchwork protection of religious freedom, and religious freedom is very fragile in Australian law. The reason why this has not come to the fore before is because it's sort of been baked into the fabric of our law, coming from a Judeo-Christian tradition, that there was these wide freedoms that were assumed to be celebrated by Christians and enjoyed by Christians, but not actually specifically protected in any law. And that is increasingly now coming under scrutiny as there are new rights that are being protected, as there are discrimination statutes that are being passed that give particular protection to certain attributes. Religious freedom never has had that specific protection at law. And so it's fragile, and it's patchwork protection. And the difficulty is, where it's protected by an exemption, that is a very poor way to actually recognise religious freedom. Because if you're told you're given an exemption from a discrimination statute, it appears to other people, to other sections of society, that you're being given a free ride, that somehow there's something that no one else is allowed to do, but Christians are given privileged status to be able to be exempt from that law. And that's often how it's presented in the media, but it's not an accurate portrayal of what Christian freedom needs to be, which is the freedom to teach and to manifest belief in accordance with the orthodox beliefs of Christianity or the orthodox teachings of these religions.